watching so that our embarrassment may actually help educate more people about what they need to do.
Courtroom, and the court, even though it may not have specifically by its terms specifically included this hearing, so I just need to know, is there any objection by counsel? From the court standpoint, it's perfectly fine, but if there's an objection by counsel, I would need to hear it just so I can address it.
No objection, Your Honor.
Okay. In that case, you're more than welcome to video, because I have no objection. Okay. So, it is going to be the 1 o'clock hour, depending on which clock or watch you're looking at. So, let's get called the case, and the case is Hunwardsen versus, I'm going to just use the agreed upon caption that you all utilize, not the caption that you put on the brief. The agreed upon caption would be Hunwardsen versus Penny Lifestyles DBA Real Water and ETT DBA Terrible Herbst. And who do we have here present in court first, please?
Your Honor, Dan Polsenberg, Dan Waite, Abraham Smith from Lewis Roca for ETT.
So is Ms. Rojas joining us?
No, Your Honor, she's in court somewhere else.
And Mr. Boho's also not joining us?
He is also not joining us.
Okay. Anybody remotely want to make an appearance or just observing?
Your Honor, Eric Pepperman for plaintiffs, but I'm just observing today.
Okay, thank you.
Joel Ledoux for Real Water, just observing.
Okay. We have another name that's down below, Mr. Downs. Is that with this case? Okay, no worries, just want to make sure. Because if somebody thought they had a different hearing, this is our own hearing for this afternoon, so I want to make sure nobody was waiting for something that did not exist. Okay, so what we have today, as you all know, was the scheduled date for the sanction hearing. I'm sure everyone appreciates this is the last thing that this court wanted to do, but for some of the people in this courtroom, they know that this has been ongoing conduct since last year, and that the court put them fully aware that there would need to be a hearing back in December of 2023, actually on December 27th, and even before then, but then it also continued on January 3rd. It then got worse and continued on the 26th, 29th, 30th, 31st, throughout other days of the trial, and including with regards to the most recent, which then we had the issue on February 2nd and other issues. And so what the court's hope was is that in the various ways that the court tried to rectify the conduct and give notice and ask the counsel who was at issue, this is all AT&T Terrible Herbst counsel, and part of the reason why I'm saying some of this is I am appreciative that some of you here in the courtroom weren't in this courtroom in December and early January. And what I'm also cognizant of is the quote brief regarding the scheduled hearing is a pretty piece of revisionist history, which is not even a chapter in a book of the issues because it doesn't go back to December. It doesn't address many of the issues. It doesn't even address the contribution that had to be made because of conduct back in the time of the calendar call. And I'm thinking that maybe some of the individuals in the courtroom, they may not have known this until the court is saying it, because given the fact that several of the counsel here in the courtroom have appeared before this court on multiple occasions and have had absolutely no issues, in fact, just the opposite, well-reasoned arguments, well-reasoned briefs, you can appreciate when I saw said brief, in addition to the lack of addressing all of the issues, it also has material misstatements, which has significant consequences and doesn't mention specific directions by the court in specific transcripts, so it does not look like anybody looked at any said transcripts and the specific directions, including the very day in which said first ex parte communication took place, when the court at approximately 8:58 p.m. said, "Do not contact my JEA," on page 21 of the transcript of that particular day. And so where I'm going with that is you can appreciate this court is fully aware, and I'm sure counsel are, Rules of Professional Conduct 3.3, right, which includes that there's material misstatements and need to rectify said material misstatements. What there also is there is material misstatements in the declaration as well as the pleading itself. So you can appreciate that the concept of hopefully this would have been rectified in December didn't work. Hopefully it would have been rectified in early January didn't work. Hopefully it'd be rectified after we treated it as a voluntary donation, but, right? And later conduct in January still didn't work with express directives to the court. And then February, and then not taking into account all the violations of motions in limine, which aren't even addressed in said brief, nor any of the other aspects that were specifically addressed, which is why this court asked if there was 2 other counsel who were participating, because they are fully aware and were participants in such, okay? So therein lies the challenge why this court had to, and then I have a statement about certain things happening on January 29th, which by definition could not have happened on January 29th, because if you look at the transcript of January 30th, the very issue at hand regarding the ex parte contact does not even occur until January 30th, hence why I'm saying that there's material in the statements in the declaration and the brief itself, not including the inconsistencies with regards to the confrontation with my court clerk, not my law clerk, while she was on her own time trying to leave for the day. So let's walk through the chronology, but I'm trying to give you all a heads up because I think some people here in the courtroom may not be aware of the breadth and depth of the issues, otherwise I would not have gotten this very minimalistic brief that seems to only cite some things which, as you can appreciate, this court would not be doing a sanction hearing if that was the only minimal issues. These are issues that have gone back since last year, so.
Can I say 2 things?
Of course you can.
And I really appreciate you going through this, and I appreciate my partner Dan Waite going through and putting this together, what he thought the issues might be. Yeah, I mean, I do, when an issue like this arises, even after the case is settled, I get involved. So the second point I want to make is, if you could tell us what the issues are that you're concerned about, I might need a little time,
Sure.
but I would be happy to address them. The other point is really the first point. And I read this a week ago before it was filed, and I read it like a lawyer. And it's like,
Did you read it by chance? Did you speak, and I'm not gonna ask about confidential communication you may have had with other counsel, but the reason why I asked about 2 specific counsel's names, right, is they were present with many, well, one was present for all of the issues and participated in bench conferences by their request. Remember, bench conferences are not part of the official transcript. Everybody knows it. It's stated multiple times.
In this case, yes.
Yes, I mean, I asked everybody, there was multiple times that we went, to bench, but parties' request, court specifically did. But, so I can appreciate maybe some people that may not participate in those bench conferences, but all the rest of the issues, I'm glad to go through because you can appreciate.
Oh, and I took,
Mr. Polsenberg, do you see what I'm raising? The transcripts with all the post-its of all the different issues,
and I
a lot of different
really
issues, yeah.
appreciate that, but where I'm going is, when I read this a week ago, I read it in a lawyer-like fashion. It's like, yes, this is how you apply this rule, and yes. Then when I read it and reread it and reread it the last couple of days, and I appreciate the court saying this is not the kind of thing that the court would be concerned about.
Well,
but I also,
hold on a second.
Actually,
it was not the kind, I didn't say it's not the kind of thing the court would be concerned about. It's
not
not
the
the type of
you
issue
would-
that I would be doing a sanction hearing because I have done so many different proactive steps since last year to try and not have this type of issue continue, which is why this court used the term that it did as far as the series of issues and walked it,
I
was willing
appreciate
to walk it through, so.
Yeah, I appreciate the correction and the distinction because I'm not saying you would be concerned about these things, but the brief did kind of strike me a little as being tone deaf. So I wanted to start out today by saying, I understand trials. I
And
used
you
to teach.
understand it's not only tone deaf, well, your word's tone deaf, it's inaccurate and has misstatements.
And that I'm not
has
aware of.
strong inconsistencies.
So if you would like to, but I also need to apologize to you that even if there aren't rules, there twice where we say it, once where we say almost exactly, that it didn't violate any rule except for the rule of courtesy and common sense. And the more I thought about that, the more I thought, we still need to apologize, even if that's the case. We shouldn't have made things more inconvenient and worse, frustrating for you. I understand that trial is difficult for everyone, sometimes especially the trial judge. I used to teach a seminar back when Joel was at the firm called The Psychology of Mistakes. And the fact that under the high pressure situation of trials are actually designed to create mistakes so that people are caught off guard. And I know there have been mistakes here, discourteous behavior to you, but if there's more there, and we tried our best to figure out what it is that you wanted to address, but if you want to set out what it is, I'd be happy to go back and take a look at everything.
Well, there's at least one attorney in this courtroom, okay, and that's part of the concern, is I don't have even all the attorneys that were significantly involved and made actual statements to this court that I was gonna ask some questions on, okay? And like I said, I left it open to you all because realistically, the hope was, look, get it all taken care of and the court may need to address what it needs to address. But by the time I got this brief with its major inaccuracies, and it's basically we're kind of above the law, it's the way it really came across. And remember, this is not, the court doesn't get frustrated. This took hours and hours where jurors were standing in court, out in the courthouse, okay, not having the trial time. Counsel had to expend hours and hours of not only trial time, but pre-trial time, including the week between Christmas and New Year's, as a result of the conduct of counsel from ETT Terrible Herbst. And I'd have to use that as a grouping because you're here as a group. I appreciate some of you weren't even in the case at that time. But remember, this is a sanction hearing for ETT/Terrible Herbst in the conduct of counsel. And I was told none of this came from the client. And in fact, I think the client was, well,
From the stuff that we've laid out clearly in my mind, it didn't come from the client.
Mr. Waite made a direct statement that it didn't come from the client.
Yeah, and we said it in the brief, that it should be the lawyers, not the client. But I doubt there's anything else that you want to add, that it would have been the client other than the lawyers.
And that was my understanding, but that's why we tried to rectify at the beginning. I'm not even sure if you even knew that there was a donation of $1,000 paid in January because of violations.
To Shade Tree. And I would have picked a different charity, but that one's good
Well,
too.
the court's not gonna go, the charity chosen,
Was by, I believe, Mr. Odu.
we'll just leave it as normally donations in lieu of are due to a facility that engages in education for those less fortunate in the legal aspect. Did the court say that in open court? Yes. Safeness is a wonderful charity. The court doesn't take issue with safeness, but even the fact when the court discusses something, that doesn't even, that had no aspect in today's sanction hearing, let me be 100% clear.
Right,
But
but I totally hear you, and Judge, I need you to hear me when I say I hear you. As I was just saying, I would have picked a different charity in light of the court's comments. But I understand there's a deeper issue here that you and I both want to solve.
So let's walk through the deeper issue so people.
Please.
Okay, and like I said, some of the attorneys here in this courtroom are fully aware of it because they were here. Okay, and that's part of the challenge because I see a declaration in a brief that per se, and we'll walk through at least some of the misstatements in here.
Let's do.
I'm not gonna go through all of them because realistically, I'm not trying to embarrass anyone. The purpose here is to not have it happen again and to ensure that there is a process that ensures that you're not impacting a trial, you're not impacting our jurors, which is what happened here, and you're not impacting other litigants in having their own cases heard, okay? Which is all of which happened here, okay?
And I'm gonna add one more, and I know you say you weren't frustrated, but I know, I teach another seminar on judges are human beings. I know it has to be frustrating for everybody on the court side.
But frustration, counsel, to be blunt, is not an issue for sanctions. And there isn't really any frustration. I appreciate what you're saying. I referenced my beautiful crystal ball that I got from the extern, okay, which is beautiful in this crystal. But just like I can't read anybody's mind, nobody can read mine. And I really am not frustrated. I think you've appeared before this court enough times to know we really just try and ensure everyone has full due process, gets their cases heard, and people have a full opportunity to have their cases heard on the merits and make reasoned rulings based on that.
Totally,
There's
but if we
there's
can
no
go-
emotion there. So let's walk through.
Yes.
Okay, so, which, you understand that there's a large concern why I'm having to bring this to the attention now, when this was already brought to the attention at the time it was happening, that it would end up having to be addressed at the conclusion of the trial. And certain counsel who are sitting here in the courtroom heard that and were fully aware of that, so
And
I
I have to apologize for that.
you're not one
because
of those.
This is, I know, but I come in, I mean, my job is to come in after the fact, and that's what I often do. And so I've been in the position to try to piece it together. So with your assistance, I hope we can get the big picture.
And you understand these are all in transcripts, so, okay. You can go back to December 27th, 2023, in hearings for depot designations. I'll give you a document number 1036. If you're trying to look it up, is the transcript, okay? There's a variety of different issues that happened on that day, but I'll highlight a couple of things. The purpose of that hearing, and this was planned way in advance in accordance with the rules, was to go over approximately 19 deposition designations, potentially in lieu of live testimony. And once again, I'm giving a little bit more background because I'm appreciative that some of you weren't here in the case at that time, so that you understand the concept, right? So you're gonna hear a little bit longer version than the shorter version.
I appreciate
Okay,
that,
so-
Your Honor. Thank you.
With regards to those that hearing was specifically designated, just as it is in any other case. If you're going to do objections to depot designations, you have to articulate specific, well-reasoned objections in accordance with the rules to the specific testimony that you're objecting to. What became blatantly clear throughout that hearing, and I'll give you a couple examples. Mr. Peppermint objected, I think, the first time around, page 21 of the transcript, might be off a page or so, but that realistically, that what was happening is ETT/Terrible Herbst Counsel had just done a whole bunch of blanket boilerplate objections that did not parallel in large part to the actual depot designations to which they're raising issues. To excerpt a couple of different aspects. One of them was, starts around page 45. This is after going for around 2 hours in these because of all these, shall we say, every objection basically appeared not to be appropriate objections for what the issues were, and they also didn't have the exact to the designations, meaning an objection would be to things that really weren't objected to. But to highlight a couple of examples. Okay, so one of them was an objection that you needed expert testimony on whether or not someone had been terminated. Very person who was talking about being terminated, Mr. Bush. We only got through part of one depot designation on the 27th because of this issue, and this is after about 2 hours. We're going around page 46 of the transcript. Okay, so Amy Jones, Your Honor, okay, that's what I thought. The reason why the court had the question is because you can appreciate the objection goes to relevance. One of the objections is relevance, so the court needed to be clear who Amy and Blaine was, although it appeared who was. Okay, court declined to overrule on every basis, strongly overruling on expert testimony is needed as to who got laid off. But I'd love to hear how that requires expert testimony. Sometimes people get in the mode of cutting and pasting, and once again, my sentence and that was trying to give a benefit of the doubt. So go ahead, please. Ms. Rojas, Your Honor, I have nothing to add on those. The court, did you want to explain why it says experts' testimony is needed on who got laid off? This is the very individual, Mr. Bush, who got laid off. Testify. Ms. Rojas, it probably shouldn't, but it looks like speculation as to what happened after he got laid off. The court, but why would that need expert testimony? Ms. Rojas, it would not. Okay, so I'm sorry, so do you want to be heard? Do you want to be heard? Then Ms. Rojas says she does not wish to be heard. That's one of many examples. Then you go on to, okay. Continues on 47, okay. Then you have Mr. Parker objecting, well, still going with the expert testimony, and then talking about there was an issue with regards to Nestle or Carnation, which was given as examples of other entities in which a particular individual had worked, and how that would come in. So it's relevant. And remember, at this juncture, the court had already made a ruling that directly impacted ETT/Terrible Herbst. So for an independent reason, these objections would not be appropriate in light of the current status of ETT/Terrible Herbst. But even if they were arguing that they still wanted to preserve the record, which the court was giving them the benefit of the doubt to do so, then you still have to look at the objections in and of themselves to see if they are proper versus just thrown there. Okay, so then you go on to another. Okay, so then there's another one. Page 83. The court, hold on, relevance, form, foundation, speculation. So there was a large number, and large is a, it's not a generous, there was a large number of just multiple objections of every kind that did not make sense to the testimony and did not even make sense to the scope of the testimony being objected to. So this one was, hold on, relevance, form, foundation, speculation. We're talking depot testimony in lieu of live testimony. So it's trial testimony, right? You can appreciate whether those objections all go to trial testimony. And then Mr. House says, and hearsay, and expert testimony needed with respect to the symptoms and what's happening drinking off the line. This was a person's firsthand perception of seeing other individuals he oversaw drinking alkaline water off the line. It's not expert testimony, okay. And the court, and what sections would that be, counsel? 93. Now you're asking the court, folks, it's been very challenging. We have had 2 hours and this is being a moving target. So those new objections were raised for the first time at the hearing after there being several weeks of where the parties were supposed to meet and confer, come to well-precisioned objections that the court was actually going to have to address, the same way you would do a 2.34, but we were doing it a little bit different format to ensure that we could efficiently use the time, because there was 19 of these approximately. At least the court was told that at one point. So I appreciate the court response was, now you're asking the court, I mean, folks, this has been very challenging. It's 2 hours with a moving target, because now it's, well, we don't really mean it for this part of the testimony, but we really mean it for a different part of the testimony. No, we don't really mean these objections, we really mean different objections. Or we only mean a couple of our objections, or we don't really mean our objections, or we have no basis to say our objections, or now we're going to waive our objections. Realistically, the very things that all should have been done before the hearing commenced, if somebody had actually done anything as was the court specifically ordered the parties to do, and it's also in the court's written rules that you have independently of the court ordering it. So 2 independent bases, and 3, the third basis is you need to do it anyway for purposes of a trial. Okay, and under the rules of professional conduct if you want a 4th reason. So, okay, and then, so it goes on with this because there's a moving target as to whether or not the page and line references even relate to these potential objections. The court's trying to get a clarification. Okay, I have ones, and I was expressing, after I said challenging 2 hours and moving target. We reportedly spend 8 hours. I have ones that aren't even sections, moving targets on what objections, and now not even parsed out to which objection may apply to one particular subsection of now a broader subsection that you're asking the court to do. And please give me the page and line references, not the discussion. I'm supposed to guess which part that's going to be, please. Ms. Ross, yes or no, and then she tries.
Your Honor, are you on page?
No, 83 of the transcript.
That's what I thought, thank you.
Okay. So then the court goes on to ask about which objections are being addressed. It's throughout that kind of highlights. Then you go on to as a result of that, the court had to make a ruling, which, so after wasting those several hours, there could not be a determination on the page and line because it was done in a manner so poorly that the court really got halfway through part of one deposition, not the court getting through, it was the out. It's the end of the day, on the 27th, and the parties had no basis on which they wished the court to continue. So, you had that issue. So as a result of that, the court reminded the parties, you have your calendar call. And we went through all the things that you needed on the calendar call, 2.67 through 2.69. Anybody who's appeared before this court knows the court doesn't just say at the date of the calendar call, it's in the trial order, right? It's said before it, okay? We've had multiple hearings, all on reminding everyone that they need to have everything at the time of the calendar call, straight out of 2.67 through 2.69. So then you jump to the calendar call on January 3rd. The calendar call, as you know, straight out of 2.69, and that's mandatory language, right? Shall bring, nothing discretionary. And so we get to the issue that before that, they tried to file an OST, and so then the court goes, asks about the OST on page 68. Then the court goes, but then, so there was originally a bifurcation motion, which hadn't really been clear on whether or not they wanted the court to hear it or not. So we go through that. But then the court says, but then we got an OST on the bifurcation after you told me in open court you were withdrawing certain dates. And then we returned it because it didn't comply with the EDCR, but then we have it again. And so Ms. Ross says, last I said we filed withdrawals, both of those motions. But then they hadn't. So the court again was preparing for something, trying to schedule time right before trial. Everybody's there, impact to Real Waters Counsel, Mr. O'Do, bless you, etc., Mr. Pepperman, Mr. Parker, Mr. Kemp, right, and the other attorneys for plaintiffs. So then we get into, on page, we say we're now going to go, and after I go into that and finally get some clarity that guess what, after you're prepared for everything, no, don't really need to hear it. It is what it is. That's not an issue really for purposes of the sanction, but it gives you the context of basically nothing seems to be looked at, and then you get to the deposition. So then we go to the calendar call portion of that hearing. And so then we go into the depositions. Plaintiffs had their approximately 10 boxes with their nice labels of the depositions that they were intending to lodge. And then we did not have the depositions with regards, and we walk through each of those. And then we get to, on page, Mr. Pepperman on page 119 objects to any depositions that were not timely provided. Okay, so the court now has to deal with an objection, so I don't have an agreement of the parties. And then we have the court asks if there was a stipulation agreement. I get told that there's not. And then for Terrible Herbst, they had no depositions to lodge that day, at the day of the calendar call. So the court asked, Terrible Herbst, your position, Ms. Rojas, page 119. Your Honor, we would need to track down the Hunwardsen deposition. That would be the only one. And I believe the original is with UNFI. Okay, so then we find out later that that's not the case, but so then you walk through, the court goes through and reads aloud EDCR 2.69C about failure of trial counsel to attend, and walks through all the things that need to be brought so that everyone's on perfect notice. We talk about open court, we go into that, and then we go into going back, and I'm not going on some other conversations with regards to real water, okay, but then we go into Ms. Rojas, the court. Hold on a second, I'm going to hear Terrible Herbst. Do you have any depositions lodged? Just the Myles Hunwardsen one. So where is it? I believe it's with you in that file, so we wouldn't get that. The court, what efforts did you make to try and obtain the deposition to comply with the EDCR? Ms. Rojas, we did not make any of those efforts, Your Honor. So no effort by anybody on behalf of Terrible Herbst to even try to comply with EDCR 2.69. Okay, is there any good cause for not complying with plain language? I say at lines 12 and 13. It was an inadvertent mistake, Your Honor. We discussed Myles Hunwardsen during the meeting. We had designations, they had objections, so this should not be a surprise that we would need his deposition. Well, we've already gone past that because we already had the issue in December of not having any of the proper objections, not having all the proper designations. So by January 3rd, everybody knew you had to have the depositions because we already knew you had to have it. And plus, Mr. Hunwardsen, by counsel for plaintiffs, has stated, would be there in person. In fact, you saw him personally, was there. every day, other than sometimes when there was some testimony that his counsel stated he did not want to hear about the impacts of the various incidents that he asserted occurred. I remember the court's using certain phrasing because we have a trial and have a verdict, but I don't know about different having post-trial motions, so I'm not being circumspect, I'm just making generalizations on certain aspects that could potentially impact the trial.
Gotcha.
So,
No, I doubt I'm gonna make any post-judgment motions.
but remember, I've got everybody else, this is a public recording, we need to make sure
Right.
I don't discuss trials that still have issues that could potentially be that.
And I understand you're going through this quickly and not precisely just to inform me what the issues are, not any way that you're telegraphing or memorializing any position that you would take in the future.
You are correct, I'm reading straight from transcripts, and that's why I'm saying I'm reading straight from transcripts, okay? Because it's a matter of public record, I'm not putting any emphasis, and we can view anything by, my voice is my voice, it goes up, it goes down. I don't normally speak in a very loud voice, but I speak loud enough that people can hear me. Okay, thank you so much.
And you don't have a mask on today, so I can read lips.
I don't have a mask on, yes, because, well, we're not going there. Okay, so, after being told that there was no efforts to even try and comply with EDCI 2.69, then it goes on to say, then Mr. Prevalence reminds that he's gonna be in open court. Then the court says, right, but counsel, you understand there's a whole plethora of appellate court cases that just say in and out. Asked again why she did not do that. She says, in abundance of caution, Your Honor, I understand we can use them for any purposes, that's why we would want to lodge the deposition. And the court says, but you didn't bring it. Can't lodge what you don't bring, right? Mr. Rojas, I understand that, that's what I've acknowledged, right? But counsel, I understand there's a whole plethora of appellate court cases that just say inadvertence is not good cause, right? I mean, there's certain in our CP provisions that talk about, you know what I mean, inadvertence, but that's distinct from good cause. In fact, and when I said Severo Sandoval, and I go into Scrimer, and Severo Sandoval, and how there's a distinction of those two as an illustrative example, not directly on point, but remembering that Ms. Rojas is Pro Hoc Vice counsel to try and give a particularized example, realizing I have lots of other attorneys who are licensed in the state of Nevada, sitting in the courtroom and observing. So they should have known, okay? So then what ends up happening, I gave the parties two choices. I gave the parties the choice that the court would be able to exercise its discretion under subparagraph 5, which was making a determination, 2.69, right, as to what would be the appropriate remedy. And then the court gives the parties the choice. So then we walk through a couple of different things, okay? So now what the court said is I was holding in abeyance to see if that was the only issue of non-compliance, the 2.69, rather than make a determination right there, so I can fully evaluate the entirety of what is brought and not brought. And most of the stuff was brought by plaintiff's counsel, so there was compliance in many of the other areas. But there wasn't in the exhibits, but that's a different issue. That's all parties. So then the court says on 137. So now the court's gone through all the mandatory things that need to be provided with regards to calendar call, because I now have to circle back with regards to lodging depositions. In light of the fact that there was just one issue with regards to deposition, the court is going to find everybody listening what's appropriate is I'm going to offer both Real Water and AT&T a choice. If they want an order to show cause where they can present all of their good cause for not providing said depots today, then I will do an order to show cause hearing. Choice 2, as I heard counsel from Real Water was asking whether or not they could do a voluntary donation in lieu of sanctions and not be considered sanctions, and that said depositions would be lodged tomorrow to minimize any impact, because it's not only prejudice, right, it's impact and exacerbating and multiplying the proceedings and all those kind of things that happen. So it seems to me that those are two appropriate choices to happen, because with regards to, like I said, the courts find dismissal too harsh, default judgment too harsh, vacating the trial date really with any impact vacating the trial really have an impact with regards to members of the community. I do not find that that would be an appropriate remedy. So really we're looking at monetary sanctions or other appropriate remedy or sanctions. Any other appropriate remedy, I think, gives this court the opportunity to allow the opportunity for a voluntary donation in lieu of sanctions, because that would address the issue and the objection raised by plaintiff at the same time. It balances out different things. So Real Water, I'll ask you and counsel for Terrible Herbst independently. This is page 138. Still, do you wish in order to show cause hearing so you can bring forth whatever you wish in regards to any good cause in regards to EDCR 2.69C, or what do you request? Mr. O'Dew, we would request option 2, Your Honor. the voluntary, and then breaks up, then the voluntary contribution. Okay, counsel for Terrible Herbst, what would you like, Ms. Rojas? We would also like to make a voluntary contribution, Your Honor. The court, please do so. Make sure it's done before trial starts. Okay, Mr. Adu, yes, Your Honor. The court, yes. Have the depositions tomorrow. So the courts complied with the mandatory language. And then the agreement of all parties and the court's specific directive is that if there was not depositions lodged by the following day, January 4th, they could not be lodged for the trial because the court, not only had there not been the compliance with EDCR 2.69 at the time of the calendar call, but the court was giving, because there was an objection by counsel for plaintiffs, the court found the proper balance was to give one more day. And since everyone had said depositions, it was just a matter of not bringing them, at least that was what's represented to the court. If anyone wanted to bring a deposition, they had to the following day, and it went to all parties. And if they didn't, then they could not lodge any more depositions. That was a direct court order. There would be no reason, this is anticipating, as I'm sure you're already seeing where I'm going, with what happens down the road, there'd be no reason for anyone to try and violate the court's order and try and lodge any depositions at any time past January 4th, 2024, including when I get to January 26th, which I'm not there yet, but, okay, so then the court, reminds the parties that there's outstanding orders, because yes, ET&T and Terrible Herbst had been untimely and not submitted their orders, and those were orders on motions eliminated that directly impacted the trial, so I went over that as well, the non-compliance issues there. So, once again, trying to give a full benefit to get all these things taken care of before trial, and to try and have everything remedied so there'd be no issues that would impact the trial, impact any party, impact members of our community, and giving ET&T a full opportunity to come into compliance. So, next happens, on January 4th, there's a notice of compliance, and it shows that there's a donation made to Save Nest, okay? So, that was, we move forward. On January 4th, there was no depositions lodged by ETT Terrible Herbst. So therefore, as of January 4th, and there were depositions lodged by Real Water. So therefore, the opportunity to lodge any deposition, not only by agreement of the parties, but by court order, there should not have been any depositions even attempted to be lodged or attempted to be brought to the court or anything. That being said, we then get to January 26th. January 26th, you can look at that hearing. The January 26th hearing is document 1238, if you need it for reference. So, on January 26th at approximately 8:57 to 9 a.m., the court says, because there was issues with regards to the exhibit list was not in compliance, and okay, everybody says they want to fix it. The court gives another opportunity to try and get things fixed, okay? It's on page 21. And then the court says specifically, this is on January 26th, okay? Specifically page 21, the court says, okay, we can't have your law firms calling my JEA. Okay? And it says to add different things that people are saying in the court. We're not gonna say who's doing it, but I just wanna be clear on the record, folks, okay, what you're wanting. So clearly, then I go into how I have a wonderful JEA who's assisting on a multitude of matters, etc. But I also was in search warrant anyway. Okay, if you have any questions, page 22, I am right here in open court. You can feel free to ask me, and then we can delegate things so everyone has an opportunity to get the things that they need to get done. Okay, we appreciate it. So therein, on the morning of the 26th, in front of all counsel and in front of everybody who was observing, the court clearly says, we can't have your law firms contacting my JEA. So independent of the ex parte rules, independent of the rules of professional conduct, independent of it being improper under a variety of other rules, the court made it abundantly clear, right, that don't contact my JEA. I'm here in open court. We need to ensure to do everything in open court, right here in the transcript. And we appreciate what happens next. Unfortunately, no one decides to listen to the court. On January 26th, the very same day that I made that directive, at 4:38, there is, and the court's reading it now because I have to do this for the sanction hearing, but at the time, as I stated on January 30th, I had not looked at the ex parte communication. I just was aware that there was an ex parte communication. Please see the transcript on the 30th with the court's explanation therein. But now I have to read it because it's your sanction hearing, and now that I have to address it directly, right? So, on January 26th at 4:38, Regina Hampton from the Cozen firm sends an email without CCing anybody other than Mr. Thomasy that says there's 3 additional sealed deposition transcripts are in the inbox. It says names, and these are names that have never come up earlier, because you heard the court read that Ms. Rojas had said the only deposition transcript that she was even asking for that extra day was Myles Hunwardsen, not any other names whatsoever. But all of a sudden, for the first time, it says 3 additional sealed transcripts of Kenneth Rothel, Michael Marsh, and Robert Gallegos. If there are any duplicates in the sealed transcripts, you may let me know and we'll make sure they're picked up. There are 6 sealed transcripts to come to Department 31 by end of day. Hutt, Hudson, Uhas, Dupreet, Zhang. So, the challenge with that document, as you can appreciate, is part of this, and all counsel were made aware of this, and I'm going to walk through the transcript of the January 30th hearing, okay, is multiple challenges. 1, per se, ex parte communication. 2, you have the fact that there was a court order that you could not lodge any deposition transcripts after January 4th. On the record, all parties in agreement, and there already had been the accommodation of counsel to have that extra day, and they were already given the opportunity to do a donation in lieu of a sanction for the improper conduct. Independent reason couldn't have been done. There's no way anyone could have thought that they could have provided any depositions because of what had happened on January 3rd, separate and apart from the written rules under EGCR 2.69, separate and apart from there are brand new people that you can't do independently under the rules of professional conduct, and I feel to cite a whole bunch of other rules. I'll be glad to do so, of all of a sudden bringing new depositions at the time pursuant to what wasn't going to be, okay? And also specifically contrary to Ms. Rojas's specific statement at the December hearing, excuse me, at the January 3rd calendar call, that it was only going to be Myles Hunwardsen, okay? In addition to the ex parte communication. And in addition to the fact that that very morning the court had said, don't contact my JEA. And yes, multiple counsel were here in court and heard it. I don't think anybody can contend, although it's not even in the brief, that somehow they didn't hear it, they didn't know it, and that all those reasons would be. So completely violating court rules, ethical rules, etc., said communication was done. The court then gave the parties the benefit of the doubt on Monday, the 29th, bless you, under Rule of Professional Conduct 3.3 to see if maybe somebody was going to take back said depositions, do something with regards to the ex parte communication because of the affirmative obligation to correct a false statement of material fact, but also the obligation that if you've done something improper, giving everyone the benefit of the doubt. And that would be on Monday, January 29th. And just to let everybody know, and I'm going to read from the transcript on the 30th, it wasn't exactly subtle that those boxes were out there because they weren't even in the inbox or on top of the inbox. They were out there as a tripping hazard, as the court notes in the January 30th transcript. So you had to walk by them in order to get into this courtroom. But once again, the court trying to give everyone the benefit of the doubt that, guess what, maybe somebody oopsed, maybe somebody was not paying attention despite everything that the court had said, to get them taken care of and to not have to address the issue. However, ET&T's counsel chose not to do anything, chose not to even pay attention that there were boxes that they were doing, or chose not to even see why they would have done that. And there was multiple counsel here that all could have done so. Nobody chose to do anything. Therefore, the court on January 30th, and this is once again going to the transcript on January 30th, there's an objection by Mr. Parker.
Are you on the January 30 transcript?
Yes, January 30th transcript, page
Thank
10.
you.
Yeah, no worries, January 30th, page 10, which is document 1241. Okay. And so there was an issue with regards to improper objections, whenever that happens, it happens at bench. There was the objection by Mr. Parker, and then we get to, that then ties into trying to bring some new opinions in. So therefore, there's an issue with regards to Dr. Hudson. So lo and behold, contrary to all the prior representations, et cetera, AT&T now wants to try and utilize a deposition of Dr. Hudson. Never lodged, never properly lodged, never mentioned at the time of the calendar call, never brought to the calendar call, etc. So then the court asked the question, well, is anyone contending, this is page 16, line 18, well, is anyone contending that the court can take into consideration the deposition and testimony of Dr. Hudson? Is anyone stating it was properly lodged pursuant to EDCR 2.69C? Okay, so the court was asking that as a broad, open-ended question, once again, trying not to embarrass or put AT&T, Terrible Herbst on the spot, even though they were the ones who wanted to be utilizing it, but once again, trying to give them an opportunity to say, oops, I'm sorry, Your Honor, we inadvertently sent over depositions, we're gonna take those back or something, but they didn't. They purely knew that they were the ones that had provided all these depositions that were still sitting outside the courtroom in boxes in the main areaway, right, causing a potential tripping hazard with jurors and everyone coming through. But that being said, I have, court asks again. The court then says, so is anyone doing it? ET is not, Your Honor. Mr. Love, Ms. Rojas, properly lodged, mean or report. EDCR 2.69C. It says what it says. That's why the court cited the specific. Is it properly? Is anyone contending it was properly lodged the court timely or properly lodged under 2.69? Yes or no? Okay, so then Mr. Love, Mr. O'Dew, Ms. Rojas says we didn't lodge it. She doesn't acknowledge that they tried to lodge it on the Friday before as part of those improper depositions that they dropped off. Clearly showing that you're not having, well, you're clearly showing something. Whether it's a lack of communication, whether it's a misstatement, however you want to phrase it. Court trying to be generous, really was trying to then follow up, which you'll see later on. The court's on that, okay? So then the court says, you're saying it was an officer of the court counsel. If you all lodged properly in 2.69, Dr. Hudson's deposition date, what date? Please show me the information that you did. Goes on a few pages later, page 19. The court now is at this juncture, from this court's perspective, i.e. me, thinking someone from AT&T is going to say, I'm sorry, Your Honor, we realized we tried to do something on Friday. You know what I mean? We'll get that taken care of. Nobody says anything. So then the court has to pursue this further. So the court has to say, is everyone saying that nobody sent, okay, excuse me, let me go back. My apologies, page 19. Mr. Love says that we have to counter call, I believe, right, Your Honor. Your Honor will recall we paid the sanctions to a chair for being late and have the transcripts, okay? That's fine, it was on January 4th, it was fine, that was Mr. Love, that was real log, they did lodge some depositions, perfectly fine, in accordance with the court order, all agreement parties. Court then says, starting in 1:15, once agreed, again, the reason why the court was asking the question is that last Friday, one of the firms here should know what I'm talking about because they sent the communication. Now, the court didn't review the communication because it was ex-party communication, did not see it, did not see the other parties. Is everyone saying that nobody sent an email to my JEA late in the afternoon on Friday? And then Mr. Thompson, Your Honor, my staff may have, but court reporter, Mr. Thompson, I can't hear you, Mr. Thompson, oh. Ms. Rojas, oh, sorry, Mr. Thompson, Your Honor, my staff may have, we were in an abundance of caution delivering some more sealed transcripts. Court says, how could you under EDCR 2.69? Right, the court doesn't go into all the other reasons. Once again, we have the jury. I'm not going to try and embarrass people in open court. Okay, trying to give all benefits of the doubt, so I'm just really citing to the 2.69 issue because that really should trail into all the others because all the attorneys were there. They knew what they had done. They knew it was improper. But once again, Mr. Thompson, well, we the court. Then the court says, how could you communicate my JEA without CCing everybody else? Mr. Thompson, I understand, Your Honor. We wanted to do this. And the court says, please stop. Do you know how many times this court has asked you all to please follow the rules? Please do not engage in any ex-party communications. Are you saying that communication was CC'd to everybody else? Mr. Thompson, no. The court, is it proper to send communications to court staff without CCing everybody else? Mr. Thompson, no. The particularly when you're in the middle of trial. Mr. Tom's like, no, court, particularly when you're apparently trying to add things to a record and the court has already told you you can't. And then there's a no audible response. Okay? So then the court says, has no one noticed those boxes sitting out there? Taking a look to see whose they may be. The tripping hazard that somebody dropped and left there last week. No audible response. Nobody has? How do we respond? The court. So this raises different challenges and questions. I mean, for real water, you're saying you did timely, Dr. Hudson's on the counter call, and then the ex-party communications that purported addresses Dr. Hudson should be disregarded, what you all have to do, even though we're talking about Ms. Rojas, excuse me. Your Honor, I have to apologize. I did not know my staff sent an ex-party communication concerning. But don't you have to? She's the partner in charge in the case, okay? Because hasn't the court asked you all? Remember, the court had just said so on the Friday around 8:58 a.m. Don't contact my JEA with, now obviously don't contact my JEA. Please do not take that out of context. I specifically walked through trial-related issues because of the ex parte issue. Obviously people contact JEA all the time for general administrative, and I saw those aspects of the brief, but that's clearly not what the court was talking about, and everybody understood it because it was the context of, we were discussing trial issues, so. That being said, and then Ms. Ross, you're absolutely right, over and over and over again, not to keep doing this. Ms. Rojas, you're absolutely right, and I will talk to them. There's an affirmative representation, and she says, I was not aware of it, I obviously wasn't on it, but I will address it, and I do apologize, Your Honor, we're not asking that it be considered. So then the court says, okay, the only thing for counsel for water, you submitted the entirety, anyway, so we're going to other issues. So there I have an affirmative representation by counsel that she's going to talk to her staff immediately. She, not somebody else on some teams, which couldn't have happened on the 29th, which we haven't yet gotten to, because remember, this hearing I'm referring to is on the 30th. I am now, Mr. Polsenberg, I'm not sure if you're understanding what I'm saying, because if you were to look at the declaration attached to the brief, and in the brief, it somehow contends that the documents were picked up on the 29th.
The brief does contend to be picked up on the 29th.
Declaration does too. Could not have happened. The court didn't raise the issue till the 30th. Nobody bothered even to check the accuracy of the brief that was sent to the court. Nobody bothered to check the accuracy of a declaration sworn under penalty of perjury. Okay, so, and we'll walk back through that in a moment. So, and supposedly there was a Microsoft Teams meeting on the 29th before the issue was even raised by the court. Nobody, that's not accurate either.
And you raised it on the 30th, Your Honor?
Counsel, I am reading you directly from the transcript
Yeah.
of January 30th, 2024, electronically
Right.
filed at 1/31/2024 at 8:04 a.m. And then just read you from the pages in the
And I-
teens to the 21.
I appreciate that.
So you understand none of these alleged assertions of things that happened on the 29th can be true. Because unless somebody was omniscient and knew what I was going to say the following day, okay, and you can check court video to see when those boxes were removed. But that being said, let me continue, and you can appreciate the,
Thank you, Your Honor.
okay, so, yes, on the 30th, on page 21, is what I said, has no one not noticed those boxes out there, taken a look to see if they may be the tripping hazard, et cetera. And I've gone through that issue, okay? And that's when I went to the EDCR, and that's when I brought it to the attention. Like I said, I was trying to give everyone the benefit of the doubt on AT&T's counsel to get it fixed on the 29th in case there was an oops on the 26th, so I would not have to address it. It was only the failure of counsel to do their obligations and the rules of professional conduct, the EDCR, NRCP, et cetera, that part of the court, and then trying to bring in the information on the 30th that the court needed to address it. So you can appreciate reading the various things about what paragraph 5 had been on January 29th, certain, right, paragraph 5, exhibit 1, the declaration. It's very interesting how that could have happened, and they weren't even discussed to the 30th. And we're not even yet to the difference on whether it was my clerk or law clerk and confronting someone as they're trying to go home at the end of the day after hours, but we'll get there in a second. So, that was the 30th. So then the court walked through that. We had to get through the other issues. We went through the rest of the issues on the 30th. So, based on that representation of Ms. Rojas, that she was going to talk to, she was going to ensure it wasn't happening, right? She was going to talk to her staff as a partner, was going to ensure it, right? And that meant all, I'm not sure if you're up to 18 attorneys by that date or not, but remember, that would apply to all attorneys and all staff to ensure what was already required not to have happened under the rules. That being said, you now move forward to the trial. During the trial, and I do know Mr. Waite may have been at some of these at the bench conferences, but may not have been at all of them. There was various violations of the motions eliminate. In fact, interestingly enough, and critically, it was ET&T's motions eliminate 9 and 10. I know I specifically referenced document 1092, which regarded Blaine Jones in the opening, and in other times that those various violations. Try to address many of those at bench to try and say, we cannot continue to violate court orders and motions in limine. What kept happening, but regardless of what was moving forward with the trial, and based on realistically the courtesy of the other two counsel, they were addressing it in a manner that it got resolved at bench, the actual issue, and so nobody raised any issues that the court was not addressing it with the jury. I handled it with all the counsel, my understanding to all the counsel's satisfaction, but having to keep bringing people to bench to say you keep violating orders on motions in limine, that particularly when they're your own motions in limine, so you should know which those are. You can appreciate took extra trial time, caused extra cost and expense. Okay, it multiplied the proceedings, EDCR 7.60. So,
And Your Honor, just for my own edification or education, I was here several days, but I wasn't at any of the sidebars. So I suppose I can ask trial counsel about those sidebars.
you can, but that's the reason why I was hoping Ms. Rojas or Mr. Bobo would be here, because they could speak of it directly, because they were at all those.
Right, but as you could tell from what we filed, we didn't anticipate these being issues.
But you should have, because they were specifically stated that they were going to be issues. That if it didn't stop, that the court was going to need to address it at the end of trial with all the other issues. People were specifically put on notice. So it's in, as you can appreciate, trying to give everyone the benefit of the doubt, isolated instances, fine, but it's the accumulation and the fact that nobody seems to have told who it. I appreciate whose signature is on said brief, but I'm appreciating that probably whoever's signature, and I'm not going to call that person out, it's a matter of public record, probably was not told by all the other individuals about all these other issues that they were specifically put on notice on. And I've quoted you directly from transcripts, okay? And even to the bench conferences, even if you disregard the bench conference issues on the violation motion limines, you can appreciate why the court had to have the hearing today. But you also had the trial, so let's continue, please. So then you get to February 2nd. So now by February 2nd, the court has clearly said not to contact everyone, has already gone through everything that I've done, not only on the 26th, on the 30th, plus you have the rules of professional conduct, plus you have the EDCR, plus you have an administrative order. There is absolutely no reason why somebody would think that somehow you would type in, because you have to type in before I get to my law clerk's name on February 2nd, let me circle back to something that you brought up in the brief, although incorrectly. Okay, so the brief says, on January, I'm reading first the declaration and I'll go to a paragraph in the brief, okay, which could not have happened.
Jan's declaration?
Yes, on January 29th, 2024, which we know is not accurate, because the issue for the transcript is January 30th, so we know somebody didn't even, there's no way somebody looked at any transcripts or actually did a diligent search before actually doing this declaration and providing this brief, because there's just too many inaccuracies. But that being said, paragraph 5, on January 29th, 2024, the above mentioned deposition transcripts had been left outside in the hallway. Well, no, your runner placed them there in an inappropriate manner, okay? Nobody left them out in the hallway. You all placed them there inappropriately, but that being said, they should have never come in the first place. As I was retrieving said deposition transcripts following trial on January 29th, there it is again, which is, we know is not correct. In the hallway, I asked the clerk whether I may retrieve such transcripts from the inbox. I wanted to confirm that I may take the transcripts, so I was hesitant to pull out a separate set of transcripts from the inbox as opposed to a box of transcripts left to be picked up on top of the courtesy inbox. The clerk confirmed there was no transcripts are being accepted this time and that I may take such transcripts. The next morning on January 30th, 2024, I informed Mr. Pepper and Mr. Adu that I'd taken the transcripts. That's interesting, I hadn't even had the conversation with all counsel. So, in order to make sure neither of them sent any transcripts to the same box on January 29, 2024, or January 26th, the day I was sick and out of trial. In doing so, I was making sure I was only retrieving transcripts sent by my office. There's multiple challenges with that. Then you go to your actual brief, right?
Yeah.
Your brief says something different. If you go to your brief on page 10, it says January 29, 2024, attorney to law clerk communication. It's not the law clerk. Okay, so somebody's not even checking to see who they are potentially doing, okay? And there it says at the end of the day of trial, i.e. January 29, 2024, ET&T's counsel, Mr. Thompson, was tasked to retrieve transcripts from the 16th floor hallway. See discussion during demo transcripts in the prior section. Okay, and he was doing so. The Department 31 law clerk entered the hallway, and Mr. Thompson asked her if he could retrieve the transcript. Law clerk from Mr. Thompson that he could retrieve the transcripts, which he did. Which my understanding, that's not a correct description, in addition to having the issue with regards to 29.
I just talked to Mr. Waite, and he had interpreted clerk in Jan's declaration to be law clerk.
That's the way I read.
Okay, I'm just saying, it's, one says clerk, one says law clerk, okay? Somebody needs to look at something if you're submitting a brief to the court. But more egregiously, realistically, is my poor court clerk. After counsel, remember, this is happening on the 30th, not the 29th anyway, after both an admonition from the court on the 26th, in the presence of the attorneys noted, as well as the court's. If I wasn't clear on the 26th, do not contact my JEA and give me a long description, which I was. I read it straight from the transcript, reiterating such, and the extreme concern about it on the 30th, not to do it, how anyone could think that they could approach a member of the staff and try and engage in any kind of communication, particularly when that individual was just going out the regular door, trying to go to the elevators after their end of day, after they had clocked out on their own time, and should never be accosted, confronted, whatever, by an attorney trying to have them do additional work when they're already on their own time and are off the clock. So ex parte, off the clock, improper, plus independently, court had already twice said don't do it. Plus I'd said it in court other times, because when people were here trying to stay towards lunch, I'd be like, please don't approach my team, do everything in open court. Do you remember that specific statement that the court said? I'm here in open court, everything needs to be in open court. If there was any questions, we had just concluded for the day. If anyone had any questions on the 30th, they could have said, Your Honor, do you mind if we pick these up? Okay, plus it was really, had no reason to engage in that conversation or put my poor court clerk in a situation where she can't even leave the premises after her end of business day, and she has to, be addressed with attorneys. That's not fair or appropriate, independently of any of the rules, independently of the ex parte, and that is an ex parte communication, because that's addressing things with regards to things and whether or not you all were potentially raising an issue about the lodging of deposition, so that is substantive. That's not just a timing issue. Because at this juncture, the court would have no idea if you all were going to raise any issue about the fact that the depositions couldn't be lodged.
But I don't think that particular thing is at all substantive. I think that's administrative.
This court has a different view of the totality of the circumstances in light of the issues that could be raised. That's why the court's explaining to you and trying to go in great detail of all the various issues, okay? So, but you don't put a member of the team on the spot after hours when they've already clocked out, separate and apart from all of the ex parte aspects, particularly when the court's already said, if you have any questions at all about any of this stuff, please open court. That was a clear directive. So violating the clear directive of the court, separate and apart from whether or not it would be technically considered ex parte or administrative, because it's really going to what is the breadth and depth of the court order. Because it goes back to the EDCR 2.69 issue and the additional extension as discussed at the calendar call in the court's order of January 3rd. That being said, and also, if you look at the brief isn't even correct because not only does it have the wrong date, but this whole concept of how it could possibly happen, or that anybody's even taking care of when they're submitting something to the court on the sanction issue, and you're doing your own declaration, one would at least check the transcripts to see what date it is before doing a declaration. You have an affirmative obligation as a lawyer to do something. That's right, candor to the court. RPC 3.3, and then you would knowingly know you were incorrect if you ever checked it between the time it was submitted on the 8th and today. No such retraction change was made. So then you go on. Once again, there is nothing anywhere that it shows that Ms. Rojas actually did what she contended she did, which was a question the court was going to ask her if she was appearing today. Because this court really can't comprehend that this, how it took Ms. Rojas's supposedly statement to the court on January 3rd that she was going to take care of the issue and talk to everyone, right? It's quoted from the transcript, whether that happened or not, and whether that's candor to the court, Rule of Professional Conduct 3.3, expressly why the court didn't take action, trying to let her remedy it. It appears it was not remedied, not only by the actions that happened on February 2nd, but because there's nowhere in this brief that even mentions Ms. Rojas did anything. And as a partner, right, she would have been the one who made the representation to the court. She didn't say someone from my office is going to do something, several days later, the following week, as she was going to take care of it. Then, as you know, on February 2nd, at 11:14, contrary to the EDCR, contrary to the other rules, contrary to the court's specific directives, and you realize in order to have sent the email that was sent to my law clerk now at this point, you had to type in her name. That means you had to look in a book or something and find her name, find her email address, and type it in. This is not as if it was responding to some prior time and date change that may have come like in a prior hearing, so you inadvertently would have done so. The ironic thing of how they decided this time to do it to my law clerk rather than my JEA raises a different issue, but you had to type in my law clerk. And it's clearly, there's an administrative order, that's not a department issue, there's an administrative order that specifically says what you need to do. Right? Administrative, then you can't send something to a law clerk, you need to follow the administrative order. And particularly since you're now asking my law clerk, by the standard of this, is that for review and consideration, reading the actual email. It's not saying we're having any issues with the order inbox and so we need to submit it to you. Can you administratively handle it? No. It's to Department 31 for your review and consideration, right? Asking the department, okay? Now, with regards to certain of the statements in the brief, if you recall, it was the court that said, don't you want this on OST? And the other parties agreed to do it, right? Because remember, your client, ETT's DBA Terrible Herbst, would technically need to remain on the verdict line. Technically would not be excused from showing up at trial. Technically would be having issues of why they were not participating in the trial. So the court was trying to accommodate ETT, which want to say that I would take it on Monday before the trial continued if things got to timely. Whether ET&T's counsel chose to do it on their own client's behalf, don't see how, but it then came, like I said, this email, which cannot be considered, right? And CC'd a whole bunch of other individuals. So then did anybody retract that? No. Instead, you waited until my law clerk had to send a response email, remember we're in trial, saying the court has already directed counsel in open court multiple times on compliance with the rules and the rules of professional conduct. Attempts to communicate with the court indirectly via the law clerk is impermissible. So once again, you've got a rule of professional conduct 3.3 and an affirmative obligation. Someone should have been tracking all those names. Sorry, including yours, Mr. Paul, right? There's a whole bunch of names. Someone should have noticed that, guess what? Trying to communicate with the law clerk, but nobody does anything affirmatively. And the rules of professional conduct, right, we have the affirmative obligation. Nobody does anything. So direct my law clerk to respond. And while the second portion is our standard ex parte language with a modification, because the modification was for specifically addressing this situation, it's the standard bounce back to instruct. But even after that happened, was there anything mentioned in court like, oops, sorry, no? The court had to do it again. And then actually, which you may not be aware of, is that afternoon, Mr. O'Toole, Mr. Pepperman, and anybody else who's on from either plaintiffs or real water, is we had to take time away from our trial to say, look, and the only reason why I even knew initially about any motion for good faith being filed is Mr. O'Toole, on behalf of real water, filed a non-opposition. And so I had to ask him in open court, why do you have a non-opposition? I don't have any motion. And we then found out that, guess what, they had been sent a courtesy copy, and then tried to track down how that was possible to even address that. And then, as you probably appreciate, someone from one of their firms reached out to one of your firms to say, need to get it in so the court can consider it. And then had them, even in open court, taking away trial time, taking away time from, once again, members of our public, and incurring additional fees and costs for real water and for plaintiffs, had to address that, and then had to address to see if they would affirmatively, because of this inappropriate conduct. I mean, it's a straight administrative order. It's not exactly like this person's first one. How many OSTs had already been filed? You would note in your brief ones had been returned. So everybody knew it had to go to the department inbox, not to the law clerk. Don't type in the name, but then in open court had to address it with each of the counsel to get them to waive the one day, to get them to waive the fact that even didn't have an order yet, and it was late in the afternoon on Friday, still here on Monday, because it was no longer even just one day, it was now a couple of hours, and to have them waive the fact that anybody would be insisting anything would happen, because remember, we're trying to settle jury instructions, we're trying to get verdicts, to everything complete, all the different finalization of trial type things needed to be completed as well. It was getting close to the end of trial, trying to get all those waivers, and that's really a matter of record. I'm not gonna read that part because it really is just straight. So once again, that multiplies the proceedings. Then what happens is when the order finally is sent in, it doesn't have compliance with the administrative orders. In fact, Mr. Pepperman brings it up to say, well, Your Honor, I anticipate that if you end up seeing the order, and if you note that it doesn't have the email attachments as is required under the administrative order, and I'm paraphrasing him, he was saying that plaintiff's counsel would waive that, and he got Mr. O'Dooley to waive it as well. So like I said, great members of the bar helping AT&T Terrible Herbst out, but was taking away time from the jurors, taking away trial time, taking away time that other matters could have been done for the court's business with regards to even other issues if I was not otherwise done so. And still, then nothing gets corrected with regards to that second communication. And with regards to, you all brought up in your brief, the NEO, one would think from your client's perspective, you would want to ensure that they're not on the verdict line. You do not have to be shown still another thing. One would think that as soon as, well, I'm not sure why you delayed in even getting the motion for good faith, but it got granted because of all the assistance of your other counsel in this case. And the court immediately, look at how quickly it got turned around when it actually showed up, after other counsel had to reach out to you all. But then, why not do an NEO immediately? So that it's clear. You know, Division of Family Services, Rush versus Clark County, it needs to be an NEO. Why multiply the proceedings even more? So they have to even have that risk of, look, can we really get a final verdict form? Can we get closure of all the jury instructions? Can we get this all taken care of? Or do we have to waste more trial time and get other counsel to say, look, are you not going to object to the fact that there's not an NEO and we can still move forward realistically? That also multiplied the proceedings, EDCR 7.60. So the fact that it was a couple of hours, you know what? That's not a large issue here, but why not do it immediately for your client? And then the only response was having some computer issues, and asked, did he reach out to anyone at your firm? But Lewis and Roca was told no. Did he reach out to anybody else with any other firm? You all have 18 lawyers in this case that you said you needed, plus hundreds of lawyers and support staff throughout the country that somebody could have filed the NEO. Realistically, they're usually prepared, ready to go, right, at the time of an OST order, so they can just be filed immediately. Same thing with the order on the motion for good faith. Now, this is not a rule violation, but for your client's sake, why you didn't have proposed order at the time, you wanted to file the motion so that it could be just addressed really quickly. That's not anything that's part of the sanction hearing, but it really just shows a lack of
Yeah. Well, if
consideration.
it's not part of the sanction hearing, I won't address it, because they're actually, I think a notice of entry is irrelevant in this case, where they have consented to the good faith settlement. So they wouldn't have a substantive right to appeal. And all the notice of entry would do under Rust is start the appeal time running. So, but if that's not part of it, I don't need to get into that. One part of the record I do want to point out is that both plaintiffs and Real Water, even before the law clerk's email, had sent emails saying that they consented to this, that they had
Not properly under the administrative order.
well, the administrative order would apply if a signature were required, and for an order shortening time, it doesn't have to be a stipulation. So what they were doing was waiving any problem that they had by saying, no objection from Real Water from Wood Smith, and Kemp Jones said no objection from plaintiffs. In 2 emails, although the law clerk sent an email after that, it was responding to Cozen O'Connor's earlier email rather than to those 2. But I understand what you're saying, and I don't say those things just so my record's clear, but I understand what you're saying, and I don't want to get into the nitpicking stuff. That's how I started out, by saying, I need you to hear me when I say I hear you. There was a lot of little stuff here. There was a lot of stuff that's more than little here. There's enough stuff here. I mean, at least 2 of these guys will tell you, you could diagnose me as OCPD, obsessive compulsive personality disorder. I like things the way they're supposed to be. And in trial, they're supposed to be the way they're supposed to be. But I do see where mistakes were made here. I deeply apologize. If I'd known you were going into all of those issues, I would have prepared for all of those issues, if you would.
Just move a little closer to the microphone. Mr. Waite can move it to you. That would be good.
I'm usually pretty good at knowing where the microphone is. If you would like, I will address all of those. Irrespective of that, I need to ask the court, where do you want to wind up being, Judge, on
How
this?
about where we wind up being, as you know, with the sanction hearing, just like they said at the time, it was to give counsels, and remember, Mr. Polsenberg, it's not you specifically, it's not Mr. Waite specifically, it's not Mr. Abraham specifically, it's not Mr. Thompson specifically, it's not Ms. Rojas. It's counsel for ET&T, Terrible Herbst, had obligations. Meanwhile, as Mr. Bovo, right, all is a combined group. You have 18 of you in this case, I was told, it was 18.
We listed a lot of names from Lewis and Roca who have very little to do with this
Once
case.
again, they have appeared in this case, so they have all the obligations of appearing in this case. You even added a couple more in your most recent brief. Okay, so you've got over 18. Okay, well, I thought it was a little bit more than a dozen, but I was told it was 18, right? Nobody just, well, you all counsel, actually, I think it was Mr. Parker, but, okay. All had an obligation to comply and not multiply the proceeding. They have obligations for candor to the court. Those are significant issues. The court, since last year, has been trying to get counsels for ET&T, Terrible Herbst, to actually do something, not multiply proceedings. What happened with the deposition excerpts, completely inappropriate on so many levels, at least across the time. The amount of trial time that had to be taken to try and fix issues by ET&T, Terrible Herbst, not fair to members of our community, not fair to counsels for the other parties, in addition to the fact that it violates the rules. So then, and to say that somehow the counsels for ET&T didn't know that this is what was going to be addressed, I'm hearing you individually may not have, but counsels for ET&T, Terrible Herbst definitely did, because this court has stated that it was going to if it didn't get fixed, and has been stating such since December. And so while I appreciate people may want to bury their heads and pretend it didn't happen, it's clearly in transcripts, it's clearly in the statements of the court. And so, yes, everybody knew, who, from at least a counsel or more than one counsel for ET&T, knew the breadth and scope. So I'm appreciative of what you're saying that you personally may not have known, but realistically, that just means the other attorneys didn't tell you. It's not from the court, because the court has been telling the attorneys from ET&T Terrible Herbst that these issues were going to need to be addressed, and they're going to be deferred because I was going to see how many issues were happening because of their ongoing nature. And if anyone contends who was here the entire time that that didn't happen, then I really refer them to all the transcripts. So I'm hearing what you're saying, that you may have only had limited knowledge, but you're one of many counsels
No.
for ET&T Terrible Herbst. So
The
let's
judge
walk
under
through
due
it.
process, I think, and I've had this issue in business court before. And I certainly want to take up all the concerns that you have. And you've seen me nodding on some of these, and it, as a lawyer, as a member of the bar, I want to make sure that we have the best possible result in as many cases as we can. So I do hear you on that. I was unaware, I didn't really, and I'm counsel on this issue, I didn't realize, and I don't think I had noticed, that we were going back before the contribution issue.
But counsel, the only reason why you don't have the notice is because people on your team, your co-counsel, didn't inform you of all the issues that the court said it was going to be deferring to the end of the trial to address in the sanction hearing. That has nothing to do with the court. How many times do I need to say it? Each and every day? Oh, guess what? This is included, this is included, this is included. No. The court gave sufficient notice and has been giving sufficient notice. It's in transcripts, it's been stated, you even have statements by counsels from Cozen and Connor. So how anybody from the totality of the ET&T Real Water trial team can say that no one in their trial team knew, I don't think it's going to be appropriate. And realistically, it's up to your trial team to inform you of what the court has said so that you could be potentially fully prepared. But that's not a court issue. That's the same issue that's been happening here in this case. They're not informing people, saying that they're going to inform. It was the exact same paralegal who did it. And it really would be hard for this, and I don't have any declaration from her. Do you have any declaration that says whether or not she was ever told by Ms. Rojas, as Ms. Rojas represented in court, not to do it? Okay, was she directed to contact the law clerk on February 2nd by Mr. Thompson or somebody else? I don't have any of that information, and that really is why the court was wanting to have a hearing, is to allow you all to present everything, because the court was trying to give everyone the benefit of the doubt from the get-go, as they do in each and every case. And only because it kept on getting worse and worse and worse. And realistically, then Mr. Waite made a statement that Mr. Thompson saw certain things, but Mr. Thompson then said he never had a conversation with Mr. Waite about that. So once again, a lack of communication in between the trial team is not a lack of due process for your clients. It's realistically that people should have been communicating and ensuring compliance with the rules and oversight. That's an issue that has to happen. Compliance with the rules is the obligation not only of all individual attorneys, but also the supervising attorneys with regards to those individuals that they supervise. And so, jumping to the point where now it's almost 2:20, started at 1, so almost another hour and a half of court time instead of other matters, trying to address things that realistically would be as simple as
Right.
read.
And I don't
listen.
want that part of my argument to distract from a resolution of the issue. I started out saying I would like to find a resolution and a more permanent resolution of this issue. And so I would certainly.
Court orders don't seem to work, right? Giving a chance of doing a voluntary contribution in lieu of a sanction doesn't seem to work. Directions, right, specific court orders don't seem to work. Nobody wants to listen to those. So you can appreciate the challenge this court has is what else to have other than the evidentiary hearing, where, as I said in open court, to bring who you wanted to do, present whatever you wanted to for the grand scope of, and it was phrased as the continuing violations. Now, if you all set up a straw man and only defined it very, very narrowly and then defended those very, very narrow things, that really is up to counsel. But that's not what the court has been telling the trial team of Terrible Herbst, ET&T. Been telling them since December that these issues are going to need to be addressed in totality if they don't get fixed. And I'd be very hard if somebody under oath is going to say that that did not happen when the trial team has been here since December. Even the issue came up, and Mr. Graham knows it came up when he kind of came into the case. He was not informed of certain things, so he made some representations, and that had to get addressed. And Mr. Boho's Cohawk Vice application was opposed for the very reason that was stated to this court. The concern was that he wasn't going to be put up to speed on everything, and it would raise issues during trial to take trial time. There was a representation made in open court that he was going to read everything, was fully going to be prepared. Okay, now, so you can appreciate that those did not come to pass. Multiple representations by counsel, or professional conduct 3.3, did not happen. The answer here is, realistically, what's put in your brief of guess what, we did a little thing with some unknown people for some unknown time, you can appreciate, really comes across like, this is no big deal. So what are you proposing as the resolution, counsel? Because every state, you understand we're at contempt parse, you can always get to contempt on a 22 because of the multiple proceedings, the multiple orders violation. That's not where this court needs to go.
Right.
Realistically, we're trying to find a way that this doesn't happen again. Okay? First time happening with one law firm, okay? The other firm has rarely appeared before this court, so I don't have as much of a history with it. But the breadth and extent of the issues that have happened is not appropriate for motion days, the hours and hours it took, trial days, and that's separate apart from the per se violations and certain things that really are bar reportable. I'm trying not to go there, so I'm trying to think of what is the solution, because everything this court has tried has not worked. Specifically saying, don't contact my JEA, and then hours later, contacting my JEA, okay? Accosting or confronting my poor court clerk when she tries to leave, and then trying to say that somehow she gave permission for something. Of course, she's a nice person, she's gonna say, okay, what should she have said? I can't talk to you, she's a polite person, that's not fair to put her on the spot. Our court staff, I mean, you don't do that to them. They should be able to leave at the end of the day, okay? The per se violations of the rules, not providing depositions and then trying to drop off a whole bunch of them. I mean, realistically, you might minimize these, but you know if you were on the other side arguing against these on something for various significant trial sanctions, you know what your position would be. But what is the solution here? Because the solution isn't just pretend this didn't happen. And first off, do you all dispute any of this? Realistically, do you dispute the transcripts that are accurate?
I did not realize they were at issue, Judge, so I didn't go to those transcripts.
Did nobody tell you that I said all this stuff in all these transcripts?
I
Seriously,
didn't
nobody
think the
told you?
scope, I didn't think the scope of this went to there. I thought it went to more recent things.
They didn't tell you that I spent, okay. Well, that's a different issue.
Can we have just one moment, Your Honor?
Yeah, of course you can.
And it's funny, Dan and I came up with the same idea, which really doesn't surprise me because we've been working together since he was a first-year law student and I was old. But what we would propose is to have all the attorneys and all the staff, attorneys do 2 extra hours of ethics in courses that are geared to the issues that we're talking about here. We can even have the court approve the courses if it would like. And then have everybody who's worked on the case at both law firms,
Three law firms.
everybody who's worked on the case.
For ETT.
For ETT, yeah.
Right.
Well, I don't know, Teddy could use it too.
He's gone. He's gone.
Oh, he's gone, then it's no fun. Certify to the court that they have read or reread the local rules, the code of conduct, the administrative order, and whatever other things would be appropriate. Department guidelines. But hopefully they won't look at the copy that Abe printed for me, because it's very hard to read. So that we're looking at, really going to the root of the conduct. And I can tell you too, although we didn't present it, I could call Jan and he would tell you that Valerie, what the Zoom meeting that he talked about in his declaration, Valerie was on that Zoom meeting with the staff.
And yet, so, is there any explanation on a declaration that's patently false?
I didn't know that you were going to go to that point.
I'm just, the declaration in your brief?
About what, the date?
On the date.
Yes.
He got the date wrong.
Did nobody look at any of the transcripts? I mean, you understand when I read that, knowing what had happened and knowing the various dates, it did not look like anybody did any due diligence to actually do any research and looking at the transcripts in order to address the various things. And when I say anyone, individuals who would have been here the entirety and knew the issues, that there was communications and information. And I say that because not only does the brief only mention of the most recent issues, but what you were starting to present and what you stated is that you weren't aware of different things, which you can appreciate doesn't come as a surprise because I fully believe you, but the fact that somebody would not inform you of all the prior issues is very concerning and doesn't seem to take the issues that were addressed by the court and said that were going to be deferred, that anybody really took them seriously or had any care, because you have an ongoing conduct, and that's really the challenge. I'm hearing what you're saying, and we'll create things, but it's, it wasn't you, I understand.
Sure, but I gotta take responsibility for it, because, something like this comes up, I become captain of the ship. We worked on ascertaining what we thought the issues were. I
You're
often.
telling me no one from Cozen and Connor told you about all the issues from December or the calendar call? I mean,
I wouldn't have even asked about this. And I apologize, because somehow we were under the impression you were talking about a particular type and time frame. I totally hear what you're saying about the issues. I do. And you bringing them up causes me concern as well. And I'd be happy to address, if you would like to set another hearing, I'd be happy to address them all. I'm not sure I'm going to get you to a different place, even if I do.
This is not a court issue.
No, I don't need
a
it.
different place.
And that's why I'm saying, when I
What's the
first,
solution here
yes,
so that realistically, in fairness, think about you've got other counselors listened in on this, right? For over an hour and a half.
Right.
Think of the amount of trial time. Think of the amount of motion time. Think of the attorney's fees. I mean, realistically, I hadn't had any request by either plaintiff's counsel or defense counsel, right, for any attorney's fees component as a result of the conduct of ET&T and Terrible Herbst. But generally, you get some kind of request because it took a lot of time on a lot of days, and it sure was fully told by the court what not to do. And to highlight the fact that at 8:58, the court says specifically, do not contact my JEA, and by 4:38 that afternoon, there's a contact to my JEA, an impermissible ex parte, clearly evidences that people heard what the court said and just completely disregarded it. Whether it was intentional, whether it was inadvertent, whether it was a lack of communication, it still is a court directive that should have been communicated to the team to ensure it didn't happen, separate and apart from it should have never happened in the first place because it's an ex parte communication and it violates a court order. But on this one, we also were told by the court that morning, don't do it. I mean, separate and apart from the other two issues, so.
right, and the directive is a directive almost falls into an entirely different area. Rex Jemison used to talk about a district court's discretion, and there's some things where discretion is limited, some things where, there's a lot of discretion, and there's some areas where there's absolute discretion. Like, which table do I sit at? If you told me as defendant to sit at that table by the jury, I would have to do that. So if we can figure out a way to get, and I think it's good that we have people watching so that our embarrassment may actually help educate more people about what they need to do.
I understand the last thing in the world this court wanted to do was to embarrass anyone.
Alex here. I don't usually do this, but because it's in the context of a media request and the discussion happened prior to the hearing, I'm going to go ahead and give some remarks on Mr. Polsenberg. I heard from my camera operator that Judge Kishner felt that the media request on file was not sufficient to continue coverage after the trial. I've read the order. I think that Judge Kishner is flat wrong on this, but when she brought this up to Mr. Polsenberg, Terrible Herbst, Dan Waite, they did not exploit what I believe to be the judge's erroneous interpretation of her own court order. They allowed the camera to remain and film, and that was something that really made Mr. Polsenberg stand out as classy and extraordinary. I think a lesser attorney would have exploited Judge Kishner's interpretation and would have tried to block camera access to the proceeding.
I'm not saying
Until
you-
deferring A, to the end of the trial, B, number of bench conferences, C, the fact that this was dealt and deferred and given all the different opportunities. This is the last thing, and then even the opportunity Mr. Waite said he wanted to do a brief. I thought this would all be addressed, taken care of with a proposal instead of just now, we've done what we've done, and it's all taken care of. There's nothing to be done here, which is, well, some would reach your conclusion, okay?
Yeah.
And that presents a very large challenge because of knowing the direct inaccuracies and the failure to state several things that happened when it's known it happened. Even the failure to state the fact that there was the donation in lieu of sanctions means everyone was on notice of the specific deposition issue, which makes it even more egregious, as you know, that what happened on the 26th, because it has the violation of a court order, which even was given the benefit of the doubt, which is why the court has done everything. Verbal directions, orders, opportunity for hearing versus voluntary contribution, that doesn't work. Orders don't work. I mean, it's nothing has worked here. So I had to have a hearing because realistically, that's the next step. There's nothing else was working, so.
I hear you, Judge, and that's why I wanted to start with my point that I didn't think our brief came across the way we actually meant to come across, which is, I said it was tone deaf. It didn't come across as saying, look, we know that this was a situation that interfered, frustrated, and the process, not necessarily the court.
Okay. Seems to me that general CLE type ethics is not really going to get you. It needs to be more fine-tuned, right? It needs to be fine-tuned as to what these issues are with attendance, right? I mean, it needs to be fine-tuned with regards to rules of professional conduct 3.3, EDCR 2. I mean, there are.
Totally agree, Your Honor, which is why I'm saying we could find them and you can approve them, and if we can't find one, we'll have to come up with one of our own.
Catcher for them, right? Seriously, with the resources you all have at your various firms, can't somebody do a training session that everyone attends and everyone signs for attending? I mean, isn't that going to be more fine-tuned so
Yes.
that you
Absolutely.
have the actual issues here done? Okay, but I got a declaration. I've only pointed out a couple of things, really. Wasn't trying not to embarrass people, but there's a lot more there. Okay, this shouldn't happen again. Okay, and it's not fair to your clients.
Thanks.
Pardon? What
I
you're
was
defining-
thanking Mr. Waite because he volunteered that he and I will teach the course, including DeCosa and O'Connor. So I said to him,
Not just Cozen O'Connor. Mr. Boho's firm too.
of course,
And
absolutely.
You understand that this is an issue I really should be reporting to the state bar. I got pending Cohop HA applications for individuals that are gonna be doing multiple cases in multiple departments, including this department, right? Down the road in other real waters. You are in my Henry case. Okay, and I
Well-
was saying, and we wanna make sure it doesn't happen again.
And so do
That's-
I.
And that's the issue, is
Yes.
because this court's tried everything over several months and it hasn't before. And it's not for the lack of the court trying to give benefits in the doubt, it's not for the court being expressed when you say, don't contact somebody. Realistically, there's no more explicit way to say it. To have it happen that same day is very, very challenging. And there was multiple attorneys that heard that, and multiple attorneys who would have known that, okay? And then not to have anything from even the paralegal as to any reasoning,
Yeah.
but that presents a challenge on what she was told or not told, it's the same person, okay? That being said, we're not gonna go back for redundancy. Seems to me that what you're gonna tell me in the next 30 days, you're gonna have at least a 2-hour training session where every single attorney who is in this case, that means all 18 of you, as well as all support staff that in any way deals with the courts, is going to, the reason we need support staff is because,
No, I don't mind the support staff. I'm just trying to get whether it's support staff that was in this case or just any support staff that deals with
well, I'm
you.
gonna ask you that question in a second, because what we don't wanna have is, guess what, you do with a different paralegal and and you got the same issue.
I'm
It
very
is-
happy to make it everybody at the Lewis Roca office, except for the gaming lawyers,
I'm not saying the other lawyers that are in this case,
right?
okay? If you're admitted in this case, that's what I got jurisdiction over. It seems to me that's the Terrible Herbst trial team, right, all 18, from all 3 firms. But my concern is it's not just lawyers, there's issues of lawyers not let's put it this way, the buck stops with the lawyer, under the rules of professional conduct, right?
Right, but the education has to be to the sports staff, so they understand if the lawyer's giving a cryptic explanation of what to do, they need to understand what that really means. So I'm on board with support staff.
I'm trying to make this appropriately tailored to who it is, right? Because obviously, somebody who's a support staff is somebody who never goes to court, that's not the issue. That's why I was trying to tailor it to people who were involved with the courts, right? Involved in litigation, support staff. Because presumably you
Yeah.
have support staff that's not involved in litigation. That may not
Right.
be a useful resource or useful for their time, right? So I'm gonna leave it up to you all. I'm gonna say you've gotta be all 18 lawyers, or in this case, okay? And I'm gonna say that it has to be support staff that has been in this case. Who else you decide you want to educate is you all's determination. In 30 days, 2 hours, right? 2 hours going over rules or whatever time period you think is appropriate. It's gotta be more than 15 minutes, you understand that?
Oh, no, I got that. I'm thinking we'd probably break it into 2 1-hours. And I'm checking my calendar to see whether we
The
can
court's
do it
not
in
gonna
the next.
approve any set schedule. You are sophisticated litigators. You're long-term attorneys. You're not enjoying being here, just like I'm not enjoying being here based on your statements that you said you weren't enjoying being here. I'm not trying to read anybody's mind. But I will tell you, this is the last thing that this court really wanted to do, which is why I kept on giving everyone benefits of the doubt over and over and over again. But there gets to a certain point where there has to be a next step because all the other steps were not working. And even adding more attorneys to the mix wasn't working because it seemed to be no one was really taking control and actually addressing what needed to be done from here. There were lots of people arguing different things, but not getting things taken care of so that
Yeah.
we allow the trial without the distraction, without all the time it took of our members of the public, the jury, other issues. And that's really the bigger case here is, let's get this done correctly and people focus. And please don't submit another declaration that's inaccurate that people don't even look at.
2 things, Your Honor, if I
Go
might.
ahead, Mr. Ray.
One, I will be happy to submit a notice of compliance indicating when this is completed. Second of all, I want to apologize to this court. I have worked very hard for 34 years to build a reputation as an AB-rated lawyer and everything else that goes with that. And I apologize that I personally was not more observant in the things that occurred. Obviously, I cannot address the things that occurred before I came into the case, but and as it relates to the brief that my name is on, I don't mind saying that.
I wasn't gonna say whose name.
No, I know, you're really good about not embarrassing anyone, but I take ownership of the brief, and simply by way of explanation, not justification, I listened to too many people in the way that it was finally submitted, and for that I apologize. And I personally vow to be more vigilant, to be more diligent, and I just want to apologize to this court for the time that we've consumed and for that there's even, that these events and violations occurred.
Hopefully everybody understands this. Thank you for the apology. We understand the court. I'm not asking you all to apologize. We're just trying to find a solution here because this should not have happened. And every attempt over months to try and make it not happen was not working. And realistically, in fairness to our justice system moving forward, I didn't know, and I didn't knows, need to be somebody actually knowing what they should be doing, because realistically, while this court's not addressing any harm to the client, right, because that's not within the scope of this, that's a whole different issue. But, okay, we've got a wonderful community, wonderful professionalism. All have appeared before me multiple times. Before I was a judge, I did cases, all sorts of things. This came as a surprise, trying to give everyone the benefit of the doubt, but this really, I can imagine me having to read so many different transcripts. It came as a surprise to this court on why this wasn't just taken care of, and it was really an easy answer of, just please do what you need to do appropriately so that I don't have to have a hearing like this. I don't have to say the things and read from transcripts like I have to today. So if that's your solution, please get it done and we'll see if it works out, right?
Thank you, Your Honor.
Thank you, Your Honor.
Appreciate it. Thanks everyone for your time. That concludes it.
Your Honor,
Okay, so the 30 days from the order, is that right? Should we do you know, 30 days to get this done? Is that gonna give you the time that you need?
Do you want an order from today?
I don't, I'm asking you if you all want an order. I'm not
I
in
don't
any way
think we need
waiving
order.
anybody's, okay, remember what this is. This was a hearing to try and find out what should happen next, right? Should it be sanctions, something less than sanctions? I phrased it as a hearing, right? I didn't phrase it as an order to show cause, intentionally trying to give everyone the benefit of the doubt, trying to say that you could just wait your husband going down witnesses. I said you could have witnesses. You do it any way the parties wanted to, remote, in person, whatever you wanted, but just so that we could get this issue fixed. So if you feel that you're treating this as something that you want it to be in order, and you want to do an order, then the court's not going to preclude you from doing something. If you're preferring to treat this as you think that there's a possible resolution and that you're just going to address this as a hearing that you all came to a resolution that no order is necessary, the court is going to be fine with that, and I need to know what you all want, because remember, the court's going to be fine with how you want it done, but I'm not in any way asking you to waive anything, so
Right.
tell me what you would like.
I'm better with no order.
Is that what you all want?
Yes, please, Your Honor.
Okay,
Thank you.
thank you so very much.
And then we can do the certification by letter to you.
You all,
We'll file a notice of compliance.
Okay?
the court is not going to read, do you, if you think it's coming from the court, it's not coming from the court. I think you all understand the issue. I have all faith with the reputations and the past experiences that this is going to be remedied. And it really just needs some new faces to get it remedied. That's the way this court's viewing it. I'm not needing a notice of compliance. I believe people at their words, right? So, until proven otherwise. And so,
Thank you.
I don't need it, but if you all want it, then you can do what you wish to do. This court is really viewing this as that this court has had a hearing, we all address different issues. You understand the issues and they're going to get rectified. That's the way this court's viewing it. If you prefer
Excellent.
me to view it in a different way, let me know.
No, I like that way, and I don't think it makes sense to file a notice of compliance when there isn't something with which to comply.
But I understand you all are going to just
But we're gonna do it.
a nice educational experience, right?
Yes, thank you, Honor.
Appreciate it. Have a great one.
Your
Thanks so
Honor,
much.
I'd also like to apologize to your staff.
Thank you, Honor.